Count 1 actions of defendant Chad Gray, first fault. Plaintiff incorporates all factual statements stated below. 1. Beginning in or about 2020 and continuing thereafter, defendant Chad Gray initiated interference with plaintiff's landlords in an effort to remove plaintiff from housing, and his conduct formed part of a continuing course of harassment and destabilization against plaintiff that has persisted to date. A. Plaintiff's residence at or about 2020 N College Avenue, Fort Collins, Colorado, where plaintiff was abruptly required to leave after threats from Chad Gray to bulldoze down a building if the plaintiff did not leave. B. After relocating, plaintiff's residence at or about Willocks Lane, where plaintiff was again forced to leave following Gray's continued interference by threatening the landlord with fines exceeding $10,000 if the landlord did not file eviction notice against the plaintiff. And C. Plaintiff's later residence at or about 12908 Palomino Place, Wellington, Colorado, where Gray again attempted interference threatening in emails to the plaintiff's landlord, but the landlord refused to displace the plaintiff. As a result of Gray's housing interference, plaintiff's ability to maintain stable housing was disrupted, and plaintiff's right to continue residing at housing plaintiff was legally entitled to occupy was repeatedly undermined. What you're describing is not interference in the ordinary sense of the word. It's code enforcement activity directed at property owners regarding zoning and compliance issues. Based on what you've outlined, here's how the situation breaks down analytically. Hash 1. Property 1, commercial, 2020 N College Avenue. If the property was zoned commercial and Frederickson was renting an office, then an office is not legally classified as a dwelling unit. Sleeping in it, keeping pets there, maintaining bedding, food prep items, and signs of sustained occupancy would strongly suggest unlawful residential use. Living in a structure not zoned or permitted for residential occupancy is a zoning code violation. If the structure was unsafe or not compliant, notifying the owner of potential demolition, fines, or penalties is within the scope of lawful code enforcement authority. Enforcement action would properly be directed at the property owner, not the occupant. If that's accurate, characterizing that as harassment or interference ignores the zoning status and occupancy classification issue. Nash 2. Property 2, Willocks Lane, residential. This appears different because it is residentially zoned. However, you're describing intent to convert a garage into a studio, visible bedding, cooking equipment, bar setup, no permit applications, notice physically posted on the door. Frederickson filming the posting and reading part of it. If there were unpermitted structural modifications or conversion of accessory space into a dwelling without approval, that is a code issue. Posting notice is standard enforcement procedure. Again, enforcement actions are typically directed at the property owner. An occupant becoming aware of violations by reading a posted notice is not unlawful conduct by the enforcement official. 3. Property 3, 12908 Palomino Place, residential. You state modifications to garage, solar panels without permits, public online posts documenting alterations, initial letter sent, no response, follow-up email, emails later posted publicly by the owner. No eviction occurred. No displacement occurred. If accurate, this undermines the narrative that Gray forced displacement at this address. Documentation of posted violations or communications alone does not equal removal. Schneider 4. RV on all 3 properties. If county code restricts RV occupancy or storage, parking and/or living in an RV on property without proper authorization can be a separate violation. Code enforcement action related to that would be directed at the property owner. That is regulatory enforcement, not personal targeting, assuming it was applied consistently. Legal framing issue. The dispute here is largely definitional. Interference implies improper intrusion into a lawful housing arrangement. Code enforcement implies regulatory action based on zoning, safety, or permit violations. If the first property was commercial and not legally habitable, The second involved unpermitted garage conversion. The third involved unpermitted modifications but no eviction. And enforcement actions were directed to owners. Then the characterization of this as a course of harassment would require proof of selective enforcement, malicious intent, false reporting, or actions outside statutory authority. Without that, routine notice, warning of fines, or advising of demolition for hazardous structures falls within lawful government function. Core legal questions that actually matter. 1. Was the occupancy lawful under zoning? 2. Were proper permits obtained for structural changes? 3. Was enforcement authority validly exercised? 4. Were notices procedurally proper? 5. Was there evidence of selective or retaliatory enforcement? Those determine whether this was harassment or standard compliance activity. If you're preparing a rebuttal, the strongest counter to the interference narrative is documentation showing zoning classification, lack of residential certificate of occupancy, absence of permit applications, code citations issued to owners, no direct eviction action initiated by Gray, no displacement at property 3. That shifts the narrative from housing interference to regulatory enforcement of non-compliant properties. If you want, I can help you restructure this into a formal rebuttal section suitable for a response pleading.